Are you a U.S. citizen with a child that lives outside of the U.S. that's under the age of 18, and you want to skip the I-130 process and go straight to citizenship? Well, let's talk about it, because there is a way that you can get them citizenship without going through the I-130 process. I am U.S. Immigration Attorney Lillian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. Now, if you have been watching my series on U.S. citizens getting citizenship for their children, you know that we have talked about CRBA, which is the Consular Report of Birth Abroad. This is for U.S. citizens that have a child abroad and not in the U.S., so they can register that child's birth with the U.S. Embassy and get the child a passport. We have also talked about U.S. citizens where their child is in the U.S. in their legal and physical custody, and that child is also a permanent resident. They are able to go to the N-600 and apply to get a certificate of citizenship. This makes them skip the N-400, and they automatically become a citizen once they meet that requirement. Now, in this video, we are going to focus on U.S. citizens that have children abroad. The children do not qualify for the CRBA, right? If the parent did not meet the requirements for CRBA for the child, maybe because they were not a U.S. citizen when the child was born, or they did not have the physical presence requirement at the time the child was born, so they were not able to get them that acquisition of citizenship automatically through the CRBA. Well, if the child is not already in the U.S., the parent may still be able to get them citizenship following this process. This is done on Form 600K. This does not require the child to have a green card. It does require the child to have been in the U.S. at the time of their interview with USCIS. We will talk about that and how that whole process works, but just know that it is possible. The key difference between the N-600K and the N-600 is that even if the child meets all these requirements before they turn 18, if they're over the age of 18, you cannot file the N-600K. But with the N-600, even if they are over the age of 18, as long as they met the requirements of the N-600, which I talked about in my previous video, they can still apply for the N-600. So that is really the key difference here. This is strictly for children that are under the age of 18. So when you file this application, if the child is already over the age of 18, just know your application is going to be denied. The only person that can file this application is the U.S. citizen parent, unless the U.S. citizen parent is deceased. Then the U.S. citizen grandparents or their U.S. citizen legal guardian can also file this application. In order for the child to get citizenship through their U.S. citizen parent, while the child is residing outside of the U.S., they have to meet the following requirements. The first one is that they have to be the child of a U.S. citizen, right? That's the number one requirement. Secondly, the U.S. citizen parents or grandparents have to meet the physical presence requirement. The child has to be under the age of 18. The child has to be residing outside of the U.S. in the legal and physical custody of the U.S. citizen parent. Or if the U.S. citizen parent is deceased, whoever the child is living with has to not object to the child getting this citizenship. And then finally, the child has to be lawfully admitted and physically present in the U.S. and be maintaining lawful status in the U.S. at the time that their application is approved. I know, that was a lot. That last requirement means the child has to be physically present in the U.S. with a valid visa or valid status in order for them to actually get the citizenship. This application can be filed by the U.S. citizen parent, but if the U.S. citizen parent is deceased, it can be filed by the U.S. citizen grandparents of the child or the U.S. citizen legal guardian of the child. If the parent is deceased, though, the grandparents or legal guardian has to file this application within 5 years of the parent's death. As you all know by now, with all of these automatic acquisition of citizenship, derived citizenship, there is this physical presence requirement. It's different for each of them. So we're going to talk about the ones for a child that's residing outside of the U.S. and what physical presence requirement the parent or grandparents have to meet in order for them to be able to basically get this citizenship. The U.S. citizen parent must have 5 years of physical presence in the U.S., and 2 of those years has to be after the age of 14. Now, if the U.S. citizen parent does not meet the physical presence requirement, the U.S. citizen grandparents can actually meet this requirement. So this is the only place where if the parents don't meet the physical presence requirement, they can use their own parents, U.S. citizen parents' physical presence to meet that requirement. So if they're using the grandparents still have to have 5 years of physical presence in the U.S., and 2 of those has to be after the age of 14. So this is not where you can count the parents and the grandparents together to make up for the 5 years. No, it's either the parent has the 5 years or the grandparent has the 5 years. It's not that the parent has 3 years and the grandparent has 2 years, so you put those together and get 5. Now, if the parent or grandparent was in the military and some of those time was spent on a base outside of the U.S. on official orders, that presence abroad, unofficial orders, is considered presence in the U.S. So just know, if the parent, let's say, is in the military, they spend 3 years in the U.S. and 2 on a base outside of the U.S. on official military orders, that time outside of the U.S. on official military orders counts towards the physical presence in the United States requirement. Please note that the parent's physical presence requirement is calculated on the aggregate, meaning every single time they were physically present in the U.S. can be used to show the 5 years. This includes time when they were not a citizen. If the grandparents are deceased, USCIS will still want proof that they were a citizen at the time of their death and that they had that physical presence requirement. So no matter what, you have to document the physical presence and you have to show that the parent or the grandparent was a U.S. citizen. The final requirement is that the child be temporarily in the U.S. by lawful admission and status in the United States. This means the child needs to come to the U.S. with a valid visa or be admitted into the United States either by parole, humanitarian parole, but they must have lawful status in the U.S. at the time of their interview. Because the N-600K, this whole process, at the end of it, there's an interview that happens with USCIS, not the embassy, which means that the child that's living outside of the U.S. needs to have a lawful means of coming to the U.S. for this interview. For parents out there wondering, how do I get my child to the U.S. when they're physically living outside of the U.S. and get them in lawful admission and get them in lawful status? There is a process with a B2 visa where the child can apply for the visa and be able to come to the U.S. for the purpose of going to this interview. There's a whole process in place for this purpose, for the child to come to the U.S., go to this interview, and be approved and get sworn in. The child needs to be physically present in the U.S. because they need to go to the interview, and once approved, they need to be sworn in as U.S. citizens. They can't do that from outside of the U.S. unless the child is living with a parent that's in the military and they are stationed abroad. In that situation, USCIS will handle the process, but the child does not have to be physically in the U.S. to be approved. But if the child is not living on a base somewhere with their U.S. citizen parent that's in the military, the child has to come to the U.S. in lawful status in order to go to their interview and be sworn in as a citizen. Remember, if you're watching this video and you want to know if you qualify, you want to know if you are on the right track with your immigration process and you may want some help with your immigration process, then go ahead and reach out to me. I will be happy to schedule a strategy session for you so that we can discuss your immigration need and how I can help you with that process. You can schedule that by going to my website, lillylegal.com, and clicking on Contact Us. You can schedule the date and time that works best for you right on that website. You can also call my office at 508-443-1788. The documentation and evidence you need for this process are the child's birth certificate. If the parents are married to each other, their marriage certificate. If the parents are married to each other, but they were previously married, proof that those prior marriages ended. Evidence that the parent is a U.S. citizen. This can be a birth certificate. This can be naturalization certificate, U.S. passport. Just proof that they are a U.S. citizen. If the U.S. citizen parent is the father and the child was born out of wedlock, meaning the parents were not married to each other at the time the child was born, the father still has to show that they legitimized the child, either through the laws of where the father resided or where the child resided. There needs to be documentation of legal custody. There needs to be a form of documentation of legal custody in cases of divorce, legal separation, or adoption. So in a case of divorce, your divorce decree, your separation agreement should have who has legal custody. If the parents are sharing legal custody, then that's okay. But if the non-U.S. citizen parent is the one that has full legal custody, then the U.S. citizen parent cannot actually go through this process. Okay, you can only go through this process if you have legal custody of the child. Next, you want documentation showing that you meet the physical presence requirement, either that the U.S. citizen parent meets the requirement or that the U.S. citizen grandparents meet this requirement. This can be documentation from schools, work, hospital, whatever records you have to show that you were physically in the U.S. for 5 years is what you need to provide. You also want documentation showing that the child is in the U.S. in lawful status. This evidence can be presented at the time of the interview. You don't have to include it with your application. If either the child, the parents, the grandparents, if you're using the physical presence of the grandparents, has changed their names, you want documentation showing that legal name change. Something else that's unique to this application process is if any of these documentation is already in a USCIS file, either the applicant's USCIS file, the parent's USCIS file, guess what? You don't have to include it. If they already have the records, for example, if you do not have your parent's US passport or naturalization certificate, you can ask USCIS to pull that because it will be in their records. Okay. So a lot of these, if it's stuff that's already in the USCIS file, you can skip, but only if you know for sure that USCIS has records of it. Now let's talk about the interview. USCIS requires the applicant to show up for the interview. The parents must also go to the interview with the child. USCIS also have the right to waive these interviews. So if they have everything they need, they can choose to waive the interview requirement. But remember, the child still needs to be sworn in as a citizen, and that takes place at USCIS. So regardless, the child needs to have been in the U.S. So the application can be approved without an interview, but the child still has to legally come to the U.S. to swear in and take the oath of allegiance to become a citizen. If the officer approves the application at the interview, they can actually do the oath of allegiance right there. I can tell you when I applied for my certificate of citizenship through the N-600, because I was physically in the U.S., the officer was able to look through my application and it's like, okay, approved. Now raise your right hand. So it can be that fast. And sometimes people are expecting like a whole to-do, but it's just not, okay? They can choose to do the oath of allegiance right there. And you walk out of there from coming in on the B2 visa to now being a citizen and going off and applying for your passport. Once you take that oath of allegiance, you then get your certificate of citizenship. If the child is under the age of 14, the officer can choose to waive the oath of allegiance requirement because the child may not understand what they're swearing to, right? So the officer can always choose to waive that for a child that's under the age of 14. Now, To recap everything we've talked about today, first, a child that's outside of the U.S. may qualify for citizenship if the parents are U.S. citizens. They have the physical presence requirement of 5 years. If the parents do not, the grandparents can also meet that physical presence requirement of 5 years. The child is in the legal and physical custody of the U.S. citizen parent, even though the child is living outside of the U.S. Finally, the child is legally in the U.S. for their interview and at the time that their citizenship application is approved. It is one of the tools we can use to get someone from not being able to come to the U.S. to not only coming to the U.S., but being a citizen of the United States. If you are wondering if your child is a U.S. citizen, if they can qualify for the citizenship process, go ahead and schedule a strategy session with me. Let's talk about it. If you have any other immigration needs and you are looking for guidance, you're looking for someone to walk you through this process, hold your hand through it, go ahead and schedule a strategy session with me, because that is the best way for us to know if we can help you and what the process of helping you looks like. You can do that by going to my website, lillylegal.com, and clicking on Contact Us, and you'll be able to schedule a time and date that works best for you. You can also call my office at 508-443-1788 and get your strategy session scheduled.